Hey everybody.
Hello.
Hi. Happy whatever day this is, Wednesday. Not Wednesday, it's Thursday. Whew, Natalie. Um, we are going to talk about independent contractors and employees today. So that's fun, for a whole lot of reasons that are kind of everyday for us. I know I often say a thing that isn't quite technically right, but sort of lands in the right way and tell people the government regards everyone as an employee until proven otherwise. And of course, I'm like, playing on some phraseology and there's no law that says that, but it is effectively what it is. And I think it's effectively the opposite of what a lot of like super small business owners think. But we're talking to a little bit bigger organizations here. And Brian, I'm gonna sort of jump in and start with you, and I'm gonna jump in and start with what happened last month. So, on the 26th, we got notice that the DOL proposes to scrap the six-factor test that came out during the last administration. Because we got to keep everybody's head spinning and all this stuff, but we just got notice that we're going to drop the six-factor test and we're going to go back to the two-factor economic reality test, which focuses mostly on worker control and whether or not that person profits and has profits and losses related to the work that they're doing as a contractor for our clients. Um, for a company that has a whole bunch of employees and already has some 1099 workers on the books, what does that rule mean? Do we wait and see? Do we start working on it now? I mean, I think a lot of times the decision's fairly cut and dry, but gosh, sometimes for some of those long-term projects or not clearly delimited projects, it really is just kind of confusing. So Brian, I guess the question is, now that we know there's a proposed two test situation coming down our throats again, what should employees do, or employers do rather?
Yeah, this is a really complex topic that sounds super simple when you just look at it on the surface. Um, and I the change, I think that the easiest way to think of it is this shift in the DOL enforcement priorities. It does not change the law, and it doesn't change plaintiffs' attorneys' mindset. And on top of that, different different regions have different tests. So even though the DOL's guidance is changing, that does not absolve a business or act as a shield for your business. One of the most important things in a situation like this is to catch it early. You'd rather have the DOL talk to you about this than a plaintiff's attorney talk to you about this. But it's much more ideal for you to talk about this with your attorney before anything serious happens.
Yeah, I think that's right. Um, I'm going to expand on that, Brian. So, in the scenario where the DOL does formally announce that they're going to this two-factor test, that will tell us something. But sort of in the meantime, and even if they don't, we can say that probably the Trump administration is not enforcing the Biden administration's rules that it doesn't like, whether or not it does whatever it does with this new proposed rule. And then we have people being moved and contractors and former contractors. Maybe they've moved on, maybe they've been converted, and there's a lawsuit that comes up. So, what do we think about if somebody was properly categorized in any particular time, but not the time of a lawsuit? Or improperly categorized at any particular time, and then we have a lawsuit.
Yeah, I think I understand what you're asking. And what you're hinting at is when companies have an issue with their independent contractor classifications, it's usually because they have a former employee bring up the issue. What we see happening most of the time is former employee goes to an attorney or does some internet research talking about wrongful termination, which isn't really a concept under the law. But then they somehow get directed to, generally by an attorney, how are you paid? Because mispaying one employee is problematic, but when you mispay 500 employees minimum wage and overtime, that's where the money is for a plaintiff's attorney, and that's where it's really going to hurt your pocketbook as a business.
Yeah, and to couple or kind of to make what you were saying even a little bit scarier, when you were saying when an employee does this and an employee does this, I know what you meant was somebody who should have been regarded as an employee, even if you called him a contractor. So sort of everything you just said, plus improperly categorized contractors who should have always been considered employees. Go to
Right.
a plaintiff's attorney or talk to ChatGPT about their wrongful termination claim. Yeah.
Absolutely. And I think you bring up an important point that I kind of glossed over is that business owners don't decide who is an employee and who is an independent contractor. You might get to make an initial decision, but that decision gets out of your hands when you don't have proper documentation and you've made questionable decisions uh, in your classification decisions. And so you can call anybody an independent contractor, but unless the economic realities of the situation make them an independent contractor, they're an employee.
Yeah, that's absolutely right. All right, Amber. So now we are thoroughly scared. Brian scared us. But from HR side, if we've got an organization and they've been operating with 1099 workers for years, we have this rash of clients that is like, well, we leave everybody as a 1099 for 2 years and then we make them an employee. Or now that we're a big enough company, we're moving everybody for 1099. It's time for us. We're grown up enough to have them be, which is not how you're supposed to measure these things. But we have a company that has all these 1099 workers. They've never really analyzed it. Um, the relationships just aren't properly structured. What does a classification audit look like? What does it do if somebody wants to come clean?
Sure. So that looks like you're going to start by pulling a list of all of your workers, and looking at some key factors that, what is the difference, even if it's not on paper, in that person, an independent contractor potentially, and an employee? And is there a differentiation there, right? So the length of the engagement that they have, how many hours they work for full time, that's one example of being could be a red flag. How integrated they are within the company. And so just really looking at the agreement, looking at the invoices, the payment records, just really pulling all of that information and holistically looking at it, right? Because it's not just one thing. A lot of companies I see, they'll have the same exact onboarding structure for an independent contractor as an employee. And so they're in Slack, they're in Teams, they're talking. I mean, you would not know the difference on the outside if you were to look in. So you can have the best contract in the world and it look great on paper, but if they're, practicing these things on a day-to-day basis, um, that means that they could potentially be an employee. So I think holistically looking at who controls the work, do they make money? Can they lose money? Are they integrated in the team? Things like that. Is where I would definitely start. And like you said, things change quickly. So even if it's been done for 5, 10 years, it's gone through multiple managers, multiple levels. Evaluating that every so often is extremely important.
Yeah, and Sarah, I'm about to transition to you, but one of the things I'm thinking about as Amber talks is a client that we both know of that the owners of the business regarded themselves as independent contractors. And I mean, you couldn't be more integrated into an organization than being the actual owner of it. So I don't know what I had for you there, Sarah, but my question to you here is to transition a bit to the contract that designates somebody as the independent contractor, as the employment. the employment basis. So if we have an independent contractor agreement, so says it on the title of the document. Is the title, is that what controls? What other factors within the meat of that agreement should we be looking at to help determine whether or not somebody is a proper contractor or an employee?
Yeah, so a lot of times people think if they attach the label that they want, it automatically is going to be the label that applies. So there's a misconception that 1099 workers are the easiest classification just for administrative purposes. A lot of times people get overwhelmed with the payroll withholdings, different employment law concepts. And I just say reach out early. It really isn't as overwhelming as it seems. Like the first employee you have, it's a bit of a learning curve. But after that, like you'll see, it's really nothing to be scared of or to do sketchy things on the backside to avoid an employee classification. Just get ahead of it. Oftentimes, we'll see people come to us with draft independent contractor agreements that actually, once you read the job descriptions and the different control mechanisms in place, it's basically an employment contract, but with a different label attached. So just really know that the substance is going to apply for whether or not your label can be properly affixed to it. And then also whatever you write down. So even if you were to modify your 1099 independent contractor agreement, so like based on the contract, they really would be an independent contractor. If you just completely disregard what you've written down and start treating them as an employee, you're still in trouble. So make sure not only if you're really think critically whether you need this to be a 1099 worker, whether that classification can stick is the first step, and then document it correctly, and then actually look at your documentation and make sure that in practice that's what you're doing.
Sarah, does it I know that it's certainly not a bad practice that you only agree to contract with contractors who have a company. I know that's not a bad practice, but is it a safeguard? So, and does it matter if that contractor has an LLC or a corporation or, PLLC? Does it matter if a contractor has a company that they filed with the Secretary of State to call it a contract situation, or do these agencies see through that sometimes?
So it can be a layer of protection, but don't expect it to be an absolute layer of protection. You still want to make sure, like, even if you are paying this other LLC and your contracts with the other LLC, and you have a really good agreement that makes it look like you guys have enough distance where the 1099 classification is proper, you still have to make sure how you're actually treating them aligns with a 1099 worker classification. So for certain business models, this works quite well, that they just have a lot of relationships with other LLCs and 1099 a lot of people, but it really depends on the stage your business is at, and also whether you have core employees you can rely on. Oftentimes, what I see is that you have someone that's they're an entrepreneur, they're super ambitious, they think they can do it all, and at a certain point they realize they can't do it all, and they start leaning on contractors a little more heavily than they should instead of like an employee network. So I think just really recognize where you're at in your growth cycle, and what sort of team you need to build at that particular stage.
And Brian, sort of somewhat unscripted here. I'm going to go to you because, as I was looking at this, I'm sure you know what client I'm thinking of that you and your Renee raced off to take care of. And we had to ask, I think, hundreds of people about their employment situation, and, sort of a dramatic instance that we got brought into. But I wonder, we weren't the primary attorney, that we weren't the law firm handling most of that work. So we had this client. They had a bunch of contractors who should not have been. And the way that they chose to handle it was to require everyone to go form an LLC. In that moment, Brian, what were you thinking about the downstream consequences of that being how they were handling that?
Well, to some degree, that system can work. However, you better make sure that they actually are an independent contractor. If you're again, it's back to the economic realities. If you are the only source of funds and income for that LLC, it may not actually be a separate company. I was on the phone the other day with an investigator talking about a case, and she was telling me, she's like, well, I can see this one person is actually a contractor. They have a LLC for their business and they're paid in irregular increments. And so the example that she came up with, which I thought was really great, was, if you run a construction business, a tree trimmer that comes out to your site is not connected with the core operations of your business. A guy that comes out to weld the gate lock correcting, that is not connected to the operations of your business. But if you have somebody operating a heavy machine and you're in the construction business, it's very difficult to call that person an independent contractor unless they bring their own machine, and that would be somewhat of a different story. But if they're performing the core operations of your business, the economic realities will almost always dictate that they are an employee. Another way that you can think about it is, did this contractor give you an invoice?
And was that invoice just a time card with the word invoice on top of it?
Oh, well, that would be bad. Another one I've seen is people go to the link to have their employees set up a LLC and call them a 1099, but then they actually pay the employee directly in their name.
Yeah. I mean, that just doesn't get you there, huh?
No.
Okay, Amber. So again, I think you weren't kind of around when Brian was doing some of this rescue work for this client that we're particularly talking about here, but generally speaking, we're talking about all these technicalities, and there's humans on the other side of that. And so when we have 1099s that we treat the same as everybody else, we can say like that doesn't do it. That doesn't trick anybody. There's nothing tricking anyone, including those workers, to make them think they shouldn't be employees also. So what do you boil it down to? I mean, there's like things like assigning schedules, requiring attendance at staff meetings, managing the tools that are used. But from sort of a behavioral cultural perspective, I understand how people drift into wanting one system for all people, but how can we not drift the same way when we're handling contractors and employees in interconnected workflows?
Absolutely. I think that this is not intentional from a lot of people, right? Managers are taught this way to do it. It's how they're trained to operate, to be inclusive, to include everyone. To include everyone means having the same, consistency, treating everybody similarly, setting the schedules that you mentioned, meetings, the same tools. However, like Brian has alluded to, they need to have their own tools. It starts from really onboarding and having a completely separate process. They don't need to be in your HRIS system. They don't need to be in all of your meetings. I mean, if the more that they're treated like an employee, they're probably going to be an employee, regardless of what your contract says. Um, and so I think training managers is what it really comes down to as well. This is a independent contractor. Make sure, because some companies I've seen, they don't even know that that person is an independent contractor, right? It's on the back end. And so they don't know. So training a manager, this is an independent contractor. This is how we're going to differentiate them. They can still treat them, culturally and have the values at the level, and make sure they're having those. But I mean, there needs to be some differentiation there, or they need to be an employee.
All right, Amber, I'm sticking with you, but this one sort of boggles my mind. We've been here saying, don't treat contractors like employees, don't treat contractors like employees, don't treat contractors like employees. And the DOL is saying, actually, we think we want you to give contractors paid leave. So Amber, if the DOL proposed rule does require us to start issuing FMLA or FMLA type leave, how are we going to handle that from a systems perspective?
Yeah, it baffles me as well. It kind of goes against what your brain's taught in this, but I think, we're gonna have to start really tracking hours. Part of FMLA, the core of it, if someone is eligible, are those hours. Have they worked that 1,250 hours? Is there documentation, record keeping, all of these things that we're kind of taught, just invoice, kind of keep them separate. So I think we're gonna really have to kind of start that process and do a little bit more tracking in that regard and find a different way to keep that separate but still track it. I think that's definitely a new concept that we'll see if that goes goes through, but we'll have to follow that closely.
Yeah, and Amber, I'm just as you're talking, I'm thinking, okay, well, we've always had FMLA for salaried employees. They don't particularly track their time. And on the other side, we have contractors that are paid at progress points. So phase one, you get your first check. Phase two, you get your first check. So do our contracts that are based on phases then start to look like salary benefits? I don't even know how to th start thinking about this.
Yes, it's definitely, I think it's going to have to be something, this changes. I feel like every couple years we're having new changes to this. And so following that and just making sure that, as Sarah said earlier, we're staying ahead of it and making sure we do best practices.
Yeah, it's crazy to me. Hey Brian, I'm going to transition back to you for a little bit. When I was doing the TWC employer conference tour, one of the things that I learned was that the TWC picked a industry every year, focused on it. So nail salons, construction, sort of the people that often categorize folks wrong or pay people wrong. They would pick on them and then come out of it with some rules that they would just keep implementing forever. So there's that as a audit trigger. But what are the other audit triggers? How can our clients know if they are engaged in risky behavior? Is it behaviors or patterns or events that tell the IRS or the DOL or a state agency like the TWC to go look at a particular client? What are those triggers that our clients can be thoughtful of?
Sure. I think the single most important one is when you're separating an employee.
Mm, mhm.
Every time that you separate an employee, you're going to want to do an analysis of how that employee was paid before you decide to tell them they're being separated. Because I don't know that I have a specific cite for these statistics, but the single biggest reason is when an employee complains to the Department of Labor about the way you're paying them. The Department of Labor investigates every employee complaint. And so that is a major one. The other way that this comes out that many people wouldn't be expecting is the DOL and the Texas Workforce Commission do random selected audits. So you might not even have something that you've done. Yeah, and I know we joke about it. I was on the phone yesterday actually with a TWC investigator regarding they were after a client for unpaid unemployment tax related to a misclassification issue. And so this client had already been hit by the Department of Labor for the same thing. However, they didn't get the Texas unemployment insurance portion. And so they got hit again. And I think if you ask the DOL and the TWC will tell you that they don't share data and that being investigated by one does not in any way relate to an investigation by another. But this is the second client who I've seen in just the last couple of weeks
Yeah.
who had a DOL issue and then they got randomly selected for an audit by the Texas Workforce Commission. Now, I absolutely 100% believed the investigator when she told me they're unrelated, but that doesn't mean that she has all the information. I've heard a lot of people talking about the government sharing more information in its departments and systems. So I expect that this will become more common. And even if the Texas Workforce Commission and the Department of Labor aren't sharing data, I think it's very likely in the next couple of months, if not sooner, that you're going to start seeing um, federal entities sharing information between and among themselves.
Yeah, we talked about that a lot over at my NamWolf meeting. I think I told you that it was you know, all the publicly traded corporate counsel, Fortune 500 corporate counsel, talking about one of the scariest trends from an employer's perspective is that under Trump, the agencies actually are finally sharing data, right? We remember we talked about this after 9/11. We like all the agencies are going to share data, and it never happened. Like we never got good at it. We never started communicating and sharing data. But this Trump administration, those agencies have displayed that they know how to share information to go after what they're regarding as an enemy, either because of employment or, anything else. But they're actually getting it done. Um, and so that is different. All right, Amber, I'm going to go back to you. Um, because none of these big, scary, bureaucratic, technical things or agency level systems things that Brian and I were talking about can happen if we don't have people on the ground acting as actors and in an organization. So, more often than not, a contractor works for a company, the work is or becomes full time. It's been everything's going great, nobody's paying attention, and next thing you know, it's a couple of years down the road, and we start looking at it, and we're like, oh wait, actually that I know better, or I just went to the CLE and found out that it shouldn't have been like this in the beginning, or my my competitor down the road got in trouble for doing exactly what I'm doing, whatever the trigger is, but we find out somebody should be an employee. What does it look like sort of for that human and from a classification and paperwork perspective to move somebody over or to move a great many people over from contractor to employee?
Sure. So I think when you find that out, it's important to, act quickly in that regard. So once you find out, make the decision, um, decide on if you want to just in the agreement, rehire them as a W-2. You can also do things within the IRS. So they have some programs where if you found that out, you can go back and kind of limit your tax exposure. Um, and it's a voluntary program that they have if you feel like there is going to be some potential for some risk in terms of, because you're going to be liable potentially if there's benefits, there's unemployment taxes, Medicare taxes, all of those things don't go away if they were supposed to be an employee. So switching it over to now where they're an employee, you rehire them as a W-2, you get their job description, and you kind of just start to do it as if they were an employee, and then see if there's any risk on the backside of, if you need to kind of clean up anything in that regard. Sometimes it may be an employee has made a claim, and then sometimes, however you ended up finding out, just kind of making sure that you're transitioning them all and reviewing.
Right, Sarah. So let's say nobody listened to anything we're saying, and we're at the point where we want to sell our company, and we got people miscategorized every which way. Um, how does that start to look during an M&A or a sale or an owner restructuring when we know we got all these contractors that are miscategorized? We could even throw in some salary issues. People should have been hourly when they were salary. We've got all these liabilities. How does it affect the deals? Because so many small and medium-sized businesses are only doing this to sell someday. Um, and so we want that asset at the end of their career to, that they're going to pass on to their children or sell in the open market. We want that asset to be as valuable as possible. So how do all these misclassifications affect the structure, the price, the willingness, the pool of buyers available to you?
Going to make your valuation really take a hit. Whenever they do an audit of your books, see what kind of classification issues might be going on, just do their standard due diligence checks, and they see all these issues, they know it'll open them up to liability. For employee misclassification issues, particularly, whenever you sell a business, somebody else is going to have to be attached to your EIN. So when you originally get your EIN, you have your original tax responsible party, and that person, no matter how your business is structured, personal liability for misclassification issues, certain penalties, they fall back to that tax responsible party. It's not an issue until it really becomes an issue. And I've helped a couple people that had personal liability from this. So when someone wants to buy your company, they really want to know, hey, if I'm the person that's affiliated with the EIN now, what am I stepping into? What steps are you going to have to protect me from any historic misclassifications if they come back on me later? And oftentimes I've just seen people let everybody go and just, want to do an asset sale instead of an actual business sale, which means your valuation's really suffering.
Yeah, that's rough. But you touched on something. When people are misclassified, how is there personal liability within that misclassification for the owners and the operators?
Yeah, you're personally liable for the federal trust fund recovery penalty, and a lot of people don't know that. It's focused more on the tax responsible party. Sometimes, if as particularly egregious officers can get involved and they'll be interviewed and stuff, but it really boils down to who's affiliated with the EIN, and often that is an officer of the organization. Sometimes it's an owner. It really varies.
Yeah, okay.
Plaintiff's counsel will oftentimes sue the owner, especially in smaller companies, in a overtime wage case or misclassification case.
Yeah. Why not throw everybody in there?
Well, I mean, but because when you have a business only, you can claim, oh, I'll just file bankruptcy. But when there's personal liability attached, that's no longer a defense. So that really can run up the settlement value.
Yeah. Okay, Sarah, we have that Section 530 Safe Harbor guidance that was updated in 2025. And it was the first time it had been updated in a long, long time. From a contracts and sort of documentation perspective, what does an employer need in place today? How do we preserve and establish eligibility for that program? And what else do we need to know about the paper part of a Section 530?
Yeah, so really the goal of this is just you can be protected if you had a reasonable basis for your classification decision. So what you need in your file is anything to document your thinking and why you made the decisions you did. So the first step is always to have your independent contractor agreement or your employment agreement. But in addition to that, have an internal memorandum that basically says, hey, this was the totality of the circumstances going on. This was the guidance that was being circulated. This is why that we made the decision that we did. So if you do get audited, you can just document, hey, this is my train of thought, and then try to get into that safe harbor.
Amber, bring this back to our HR folks. So everything Sarah said, what does that mean about job descriptions and building out a person's work?
Um, so I feel like in terms of just making sure that they have um, the job descriptions, everything, in line with what you have for all the other employees, essentially.
But just do it, but just actually do it.
Yes, actually, actually do it.
And when things change, amend your documents. Make your documents match the reality on the ground.
Yeah. That time of annual review is a real good time to look at your job description for that person too, right? And sometimes it's so hard to convince people that those foundational documents matter. But again, here's an example that, job posting you had probably was related and but related to the job description. The job description is going to be related to your IRS filing someday. All these things that we call foundational documents really do matter. All right, Amber, I'm going to stick with you. A lot of times, having somebody be regarded as a contractor has cultural significance more than legal significance, sort of on the ground in the day to day. It generally will mean that person's a little more disposable. It generally, in different industries, either means they're cheaper or more expensive. How do we think about having a cohesive workplace when we have people who just by their designation have different credibility or are in a different class section as between the other humans and people that they work with?
Yeah, I think that's extremely important in terms of culture and, yes, they are in a different class. We want to designate them accordingly. However, um, they're not always cheaper. There's not always there's other costs, but keeping in mind they're so valuable. I think, we've been saying a lot on this call. Um, I don't want to devalue. Contractors can be amazing when there's project or there's work surges or things like that. So I think coming in a lot of times, employees really can, and managers really do appreciate them, appreciate the extra hands, appreciate the extra work in that regard. So I think just as a culture, having those values of, making sure everyone brings value, brings long term, there might not be long term collaboration, but if they do, they can maybe potentially become an employee. They can add value in different ways. So I think it's all, training the managers, making sure employees treat everyone, the same way in that regard.
Right. Hey, Brian, when we do have an issue, we've gotten a letter, we've gotten an audit notice, we've gotten something that has put us on notice that we do have an issue. What are you directing a client, an Amber, a client's Amber? What are you telling people to do in that moment of panic when we first get our notice that an agency, that an authority thinks we have an issue?
Well, I think the first most important thing is do not retaliate. That will get you in more trouble.
So
And even if there isn't a problem, you can still be in trouble for retaliation because complaints are often protected, even if they don't lead to a violation. So I think that's first and foremost. And I think the next thing that we're doing is asking the client to get us the documents and at that same time to do a real world on the ground analysis of what actually is being done as well as getting us the documents. So we want to know what you said you're doing and what you're actually doing.
So you're not focused on corrections in the moment. That's sort of phase two.
Yes, that's definitely a phase two. Because these things look back, there's not changing it right this minute is not necessarily where you need to direct your attention. Obviously, that's the very next step is to get it corrected. But like in the first moment, that's not necessarily where we're spending our time and energy. That's the second freak out.
I guess said differently, also remember that when you find out there's a problem, you're on notice to start preserving things. So don't start destroying evidence. It's already real well documented how you've been regarding people.
Yeah, I that one kind of I assumed it, which is probably not. But I mean, we do request the documents, and but in any client situation, we tell them not to destroy documents.
Oh,
So
absolutely.
that's just kind of please don't destroy documents.
Anybody got any last minute thoughts on this? I think this has been a really good one.
Yeah, I wanted to say that we haven't talked about the DOL's paid program. I think we talked about the IRS's voluntary classification. situation. But the DOL now has reinstituted the paid program, and that stands for payroll audit independent determination. And what this is basically a safe harbor for employers where when you know you've had some misclassification issues, you can go ahead and come clean to the Department of Labor, and you first of all, you don't get hit with the liquidated damages. You don't have to pay an employee's attorney's fees. So it's really an opportunity to make things right with your employees and yourself and to stay out of the government's crosshairs.
Yeah, that was a important add-on. Anybody else got anything? All right, guys.